Hi everyone, welcome to the third in the Armidale Public Lecture Series, and we've got a good turnout tonight, which is really good, about wrongful convictions in the WA police and judicial system. Before I continue, I'd like to acknowledge the former member for Armidale, the Honourable Kay Hallahan. Thanks very much for Kay for coming here tonight. And actually the newly elected member for Burt puts in his apologies, so hopefully he'll be able to come here at some stage. Okay, let's get underway. Of course, over the last 50 years in Western Australia, unfortunately, we've seen a series of wrongful conviction cases flowing from the WA judicial system. And in the time available for me tonight, it is not possible to discuss all those cases. But one of the most recent cases has involved the Perth Mint swindle and the Micklebird brothers' confrontation with the criminal justice system. The brothers have always maintained that they served time in jail only because some of the police officers involved behaved in a corrupt manner, fabricating evidence. Their court saga spans 25 years. It involves 7 unsuccessful appeals before the 8th and final successful appeal in 2004. The Micklebird saga is a fascinating case in WA judicial and policing history. It is complicated and long. It deserves a lecture of its own, and as a result I won't be dealing with that tonight. I'll have to defer that for another case. But there are a number of books that deal with this, including the trilogy by Avon Lovell, and also my own book, a bit of self-promotion, I am a politician, Brothers, Justice, Corruption and the Micklebirds, but I'll leave that for another day. I want to commence tonight's lecture with 2 of the more celebrated examples of wrongful convictions in Western Australia, that being the Beamish and Button cases. On the 29th of January 1959, Pina Berkman was startled awake by a burglar in her house. The next day, her naked body was found lying in a pool of blood. She had been repeatedly stabbed with a diver's knife. By the end of the year, with the police no closer to solving the Berkman killing, another young woman was murdered. She was also sleeping naked, in her apartment in Brookwood Flats on Stirling Highway in Cottesloe. The date was the 19th of December 1959. The woman was 22-year-old Gillian Brewer, heiress to the Matt Robertson chocolate fortune. The Berkman and Brewer murders bore similarities that were noticed by the mortuary staff when the bodies were held for post-mortem examination. The Berkman case remained a mystery, but a breakthrough on the Brewer murder came in April 1961, when Daryl Beamish, a deaf mute, was remanded in custody in relation to a number of sexual assault charges on 4 young girls, each of whom were 5 or 5 years of age. While in custody on these charges, Beamish was questioned by Detective Sergeant Owen Leach in relation to the 1959 Cottesloe Brookwood Flats murder of the 22-year-old Gillian Brewer. The police interrogation was spread over 2 days and at various locations: Brewer's flat, in a police car and the CIB headquarters. Also in attendance were Detective Jack Deering and Mrs. Florence Myatt, a public relations officer and interpreter for the WA Adult Deaf and Dumb Society, who interpreted for Beamish. On the first day of questioning, 7th of April, after first denying he knew anything about the Brewer murder, Beamish confessed. He repeated his confession the next day in written responses to questions put to him in writing by the police. Also on 8th of April, while in the Perth Police Station exercise yard, Beamish was allegedly observed by another prisoner writing on a bitumen with a piece of plaster. He wrote on 4 separate lines: Cottesloe, we're drunk, I killed lady, and 7 month. On the 10th of April, Leach queried Beamish via written questions about these lines. As to whether he wrote the lines, Beamish nodded with his head and wrote yes. But he also wrote, "Not me killed Lady Cottesloe." When questioned by the police on the inconsistency of this answer with his lines on the police station courtyard bitumen, Beamish wrote, "Father said say nothing." 2 months later, on the 12th of June 1961, Leach attended Fremantle Prison to interview Beamish again, along with some other detectives, some medical officers and a reverend who acted as the interpreter. At the interview, Beamish was taken through his answers given on the 8th of April and the written statement of confession. Beamish nodded his acceptance to each paragraph of the written statement, but at Beamish's trial, the Reverend did confirm that there were some difficulties in interpreting for Beamish. Beamish's trial for willful murder commenced in the WA Supreme Court on the 7th of August 1961 before a jury and Chief Justice Sir Albert Wolfe. Beamish's confessions or statements to the police were crucial to the prosecution's case. There was no other evidence linking him to the crime scene, although in February 1961 Beamish had gone to the Brookwood Flats to see a Susan Delaney, even though she no longer lived there. Beamish gave evidence at the trial through a sign language interpreter. When examined by defence counsel, Beamish denied the confessions. He said that during one of the police interviews, the police one of the police shook him and put his fist to his face. Also, he gave evidence that Mrs. Florence Myatt, the public relations officer and interpreter from the WA Adult Deaf and Dumb Society, who interpreted for Beamish in some of the interviews, suggested the answers he should give in relation to the police questions. At trial, Myatt denied this was the case, although she said that because of Beamish's limited English vocabulary, she modified or amended the questions asked by the police to Beamish. The jury found Beamish guilty, leaving Chief Justice Wolfe no option but to sentence him to death, despite the jury making a strong recommendation for mercy. However, because of the state government's policy towards people with disabilities, the governor commuted Beamish's death sentence to life imprisonment with hard labour. Shortly after the trial, Beamish appealed and the appeal commenced before the Court of Criminal Appeal on the 19th of September 1961. At issue was whether the Chief Justice should have used his discretion to exclude Beamish's statements to the police made on the 7th of 8th of April 1961 because they were not shown to be voluntary. The court dismissed the appeal and Beamish was incarcerated in Fremantle Prison. Julian Brewer's murder was the forerunner of a short reign of terror which shattered the illusion of Perth residents from their streets or even their homes, Julian Brewer's murder was the forerunner of a short reign of terror which shattered the illusion of Perth residents in their streets or even their homes that they were safe from violence. It began on the night of Australia Day, 26th of January 1963. It was a night of terror in the suburbs of Perth. 5 people were shot that one night in Cottesloe and Netherlands. 2 of the 5, John Sturkey and George Wamsley, died and another, Brian Weir, suffered brain damage and died 3 years later. The utter surprise and fear of the time is captured in Tim Whitten's famous novel Cloud Street. "It's right in our bloody backyard," said the Sarge. "Cottesloe, he shoots and wounds 2 in the car. Then he goes to a flat, puts a hole in the bloke's forehead. An hour later he shoots a bloke on his doorstep in Netherlands where he answers the door. Then he kills a kid sleeping on the back veranda in the next street. The CIB are shitting themselves." For days following, the people of Perth clutched at straws. Whitten records it as follows. "In their fear of the mysterious killer, people could speak of little else. The mystified police appeared helpless and confused. Indignant letters to the editor writers demanded that they ask the FBI and Scotland Yard to step in. Locksmiths and gun shops did a thriving trade. Dog homes sold out of watchdogs. 2 weeks later, on the night of 9th of February 1963, Rosemary Anderson, aged 17, was deliberately run down on Stubbs Terrace in the Perth suburb of Shenton Park. She died from her injuries at Royal Perth Hospital later that night. Police arrested her boyfriend, 19-year-old John Button, the same night. In a statement to the police, he said that after an argument over a missing piece of fish, Anderson had left his parents' Subiaco home to walk to Mount Claremont. Later, he told the police that the argument ensued after he had touched her breast during a game of strip poker played by Button, his younger brother Jimmy, and Anderson. When she left the house, Button had followed in his Simca, repeatedly asking her to get into the car. She refused. He stopped his car as Anderson approached the railway subway at Nicholson Road. After a few minutes, Button started up his vehicle, drove under the subway and turned into Stubbs Terrace. Then the story gets rather messy. Button gave two statements to police, one before and one after he'd been told that Rosemary had died of her injuries. In the first, he said he drove up and saw Anderson lying on the side of the road. In the second statement, he said that when he saw her walking on Stubbs Terrace, he decided to scare her by driving his car as close as possible to her, but instead he hit Anderson with the left-hand side of the front of his car. The first statement was made by Button at 2:15 a.m. on the 10th of February 1963. The second statement was made around 3:40 a.m. that morning. In both statements, Button said he picked up Anderson and laid her in his car. This was witnessed by others who drove past the scene. One witness followed Button as he drove Rosemary Anderson to Dr. Joseph Quinlivan's surgery nearby. By then it was about 11 p.m. Button was wearing only trousers as a result of removing his shirt during the strip poker game at his parents' home. After examining Anderson, Dr. Quinlivan telephoned for an ambulance and then telephoned the police. On the 2nd of April 1963, police charged Button with willful murder. At his trial on the 29th of April 1963, the West Australian Supreme Court found Button guilty of manslaughter and sentenced him to 10 years with hard labour. In both the Button and Beamish trials, the defence raised concerns about the confessions. Both alleged the confessions were the result of police pressure, and in the case of Beamish, was actually the result of police prompting or suggesting answers. The allegations carried no weight with the judiciary or the jury in either trial. Less than a week after Anderson had been run down and killed, Perth was to experience another murder of a young woman in her home. The victim was 24-year-old social worker with the Native Welfare Department, Constance Lucy Madrill. On the night of the 15th of February 1963, she was strangled in the bedroom of a West Perth flat, then dragged outside and placed under the rotary clothes hoist. Beamish and Button might have been under lock and key, but the Berkman killing of 1959, the rampage of Australia Day 1963, and this new outrage remain unsolved, and the hysteria gripping Perth continued unabated. Unexplained break-ins and burglaries continued in the western suburbs. Then on the 10th of August, university student Shirley McLeod was shot dead as she sat on a couch while babysitting at a house in Dalkeith. On the night of the 31st of August 1963, the police apprehended a man named Eric Cook. A husband and father, Cook was born in 1939 with a hair clip and cleft palate, which limited his speech to a peculiar mumble. The police had staked out a site on the banks of the Canning River in Mount Pleasant, where an elderly couple had come across a rifle while out walking. Cook had hidden the rifle there after committing one of his murders. He made the mistake of coming back to retrieve it. Tin Whitten in Clough Street describes it as follows. When Bill Hawker grabbed him in the dark as he reached for the rifle, Hawker wondered what sort of weirdo he had caught. This creature was burpling strange nasal sounds, and when he went to handcuff him, the hands felt slick and smooth, almost slimy. He was wearing the kid's gloves, of course, and in the policeman's anxious mood, the skin of the gloves felt creepy, otherworldly. But Hawker held on. He handcuffed him to the fence. He had him. It did not take long for Cook to admit to a string of murders. He also claimed that between 1958 and 1963, he was responsible for 6 hit-and-run attacks against young men using stolen cars, 8 attacks against women asleep in their beds, and other shootings. There was more. He claimed responsibility for the deaths of Gillian Brewer and Rosemary Anderson, for which Daryl Beamish and John Button were already serving jail sentences. How police reacted initially to these claims is unclear. What is clear that after further questioning, Cook retracted his confessions to the murders of Brewer and Anderson. Cook was charged with 4 willful murders, an attempted murder and an unlawful wounding. He was tried only for the willful murder of Sturkey, for which the court found him guilty and sentenced him to death. After Cook's conviction, lawyers for both Beamish and Button visited him on death row, where Cook again confessed to the crimes for which their clients were now serving time. These confessions, made only minutes before he was executed, resulted in further appeals for both Beamish and Button. On the 26th of October 1964, Cook was the last person hanged in Western Australia. And do remember, Beamish would have been hanged if it wasn't for his disability. The second Beamish appeal commenced on the 17th of March 1964 in the Supreme Court before Chief Justice Wolfe and Justice Jackson and Justice Virtue. I think Justice Virtue is a fantastic name for a judge. The constitution of the bench illustrated another flaw in the justice system. Because here you had the Chief Justice who had presided over the Beamish trial, and the other judges, the other two judges, had sat in judgment on the first Beamish appeal. In a 1966 scholarly critique of the Beamish case by Professor Peter Brett of Melbourne University, he was damning on the constitution of the Supreme Court for this second appeal, pointing out that the bench was being asked to decide on whether a miscarriage of justice might have occurred in their own court. And he stated, "It needs no expert knowledge of psychology to realise that any man, however scrupulous, might well be swayed unconsciously by a desire to believe that he had not been a party to such a tragic error." So you've got to understand here, you've got the Chief Justice, who was the trial judge in the first Beamish trial, was now sitting on the appeal, and the other two judges had sat on the first appeal. The well-known principle that justice must not only be done but must manifestly be seen to be done should have precluded a judge sitting in judgment on an appeal against his own decision. Brett also said it was unbelievable that medical evidence held by the Crown and sought by the defence in relation to testing Cook's veracity was not put to the court. Beamish was unsuccessful with this appeal. The prosecutor in the Beamish and Button and Cook cases was Sir Ronald Wilson, who became the first Justice of the High Court from WA. Now, in regards to the Beamish trial, he did ask a number of questions that were very prejudicial to Beamish. He brought up issues about Beamish being cruel to animals, and also in the end he brought up issues in regards to his charges in regards to the sexual assault against the children. Normally that would not be allowed, but because the reputation of the police was being tested by the defence, you then are allowed to bring evidence about the character of the defence of the offender. But another thing that in regards to Sir Ronald Wilson, the Beamish trial, was there was some medical evidence that he did not disclose to the defence, which he should have disclosed. Although at the time the practice was not as widely received or understood as it is today, where you must of course give all evidence to the other side as well. Button likewise failed before the Court of Criminal Appeal. As in the Beamish second appeal, the court held that the Crown's case was very strong and that Cook's confession to the killing of Anderson lacked credibility and was fabricated. Further, the court did not view the evidence presented by Button's legal team about other similar offences, such as a hit and run against women on 5 separate occasions, as compelling. It would be many years after Beamish and Button had served their prison sentence before justice finally prevailed to correct the tragic errors. On the 20th of December 1967, Button was released on parole, and in 1968 he married. A chance meeting in 1992 between John's younger brother Jimmy Button and Perth journalist Estelle Blackburn, and there's some books there by Estelle Blackburn on that table actually, was to prove momentous for John Button. After that meeting, Blackburn began a long and detailed investigation that led to the publication in 1998 of her book Broken Lives, which presented a compelling case that Cook killed Rosemary Anderson. This included evidence gathered from William Haight of San Diego, an expert in traffic accident reconstructions. Haight reconstructed the scene and carried out crash tests to simulate the collision that killed Anderson. Haight concluded that it was highly unlikely that Button's car was involved in the running down of Anderson. Another crucial witness in the case was Trevor Condren. At the time of Anderson's killing, he was a first-class constable in the WA Police Force and a fatal accident examiner attached to the traffic branch in Perth. On February the 12th, 1963, at the request of the CIB, he inspected Button's car and prepared a report. When examining the car, he was informed by CIB officers present that the car had been involved in an accident with a pedestrian and the driver had been charged and had confessed. He was told that the car had been involved. He was also told the car had been involved in a minor accident with a Ford Prefect a few weeks earlier. At the appeal, he said that he commented to the officers present that he did not think that the vehicle had struck a pedestrian, but he did not. At the appeal, he said that he had commented that the officer present that he did not think that the vehicle had struck a pedestrian, but he did not express this at the trial or in his report because his role was to report on the vehicle in terms of its mechanical condition and damage. In light of Blackburn's revelations, State Attorney General Peter Voss, QC and MLC, referred the John Button case for reopening. The Court of Criminal Appeal heard the appeal in May 2001 and handed down its decision on the 25th of February 2002. The court held that if all the evidence had been presented to this appeal court had also been available for the jury's consideration at the initial trial, there was a significant possibility that a jury acting reasonably would have acquitted Button. They considered the verdict unsafe and unsatisfactory on the ground there had been a miscarriage of justice. In handing down the decision, Chief Justice Malcolm said, "I have concluded that the evidence of Mr. Haight, supported by the evidence of Mr. Condren, is sufficient to raise a reasonable doubt whether the applicant's motor vehicle was involved in running down Miss Anderson on the 9th of February 1963. The evidence of Mr. Haight also tends to substantially corroborate the evidence of Mr. Cook, that being Eric Cook, whether the latter was mistaken about the side of the vehicle which hit Miss Anderson or whether he swerved off the road in the manner he described and constituted the alternative scenario described by Mr. Haight. The evidence of Cook's propensity to seek out women walking on the side of the road and run them down is compelling. In my opinion, it overwhelms whatever doubts may have been held concerning his credibility by the remarkable coincidence between his recollection of the events described in his confessions and the recollection of the victims. The fact that Mr. Cook maintained his guilt in relation to the death of Miss Anderson in the gallows confession on the 26th of October 1964, shortly before he was hanged, takes on some additional significance against the background of the other matters to which I have referred." Brett Christian, the editor of the metropolitan newspaper The Subiaco Post, had long been seeking to tell the story of the conviction of Daryl Beamish. Christian published a number of articles on Beamish in his newspaper. The 10th of June 2000 edition of the Subiaco Post contained 2 articles. One talked about Beamish's mother's hope that her son's name would be cleared, and another about how new evidence gathered for the pending appeal in the matter of Button provided hope also for Beamish. The publicity flushed out Beamish's nemesis, the now retired former Detective Sergeant Owen Leach, who was the police commissioner between 1975 and 1981. Leach was quoted in the Sunday Times on 3rd of September 2000 saying that Cook only confessed to the Brewer murder after he was sure of his fate for the murders he had done. Kerry Whallam, the author of the article, wrote, "Mr. Leach describes Cook as an unscrupulous liar and said personal contact was vital in coming to the correct conclusion in the murder. He said he was addressing today's police to enlighten those subjected to the hype over the appeal." Beamish had to wait a bit longer than Button for his day in the sun, or should I say, his day in court again. It seems bitterly ironic that Beamish had to wait until April Fool's Day 2004 for the Court of Criminal Appeal to end the cruel joke the justice system had played on him more than 40 years earlier. After a hearing referred to them by the Attorney General on a petition by Beamish, the Court of Criminal Appeal held that the original 1961 willful murder conviction should be set aside as there was a substantial miscarriage of justice. The court held that the confession of serial killer Eric Cook to the murder, including his gallows confession 15 minutes before his hand, was decisive. The court also expressed concern with some aspects of Beamish's alleged confession to the police. Mainly these related to his inability to communicate adequately, possible prompting by the police to give answers that helped their case, and the destruction of a piece of paper by the investigating officer on which he recorded questions and answers, including a denial from Beamish that he had killed the lady. In their judgment, the court concluded that it seems to us that Cook's confession is capable of giving rise to a reasonable doubt in the mind of the jury, and that when the confession is considered in combination with all the other evidence, there is a significant possibility that a jury, acting reasonably, would have acquitted Beamish. And as I said, do remember, he was sentenced to death originally. The successful Beamish and Button appeals were not the only cases to rot the public confidence in the police and judicial system of WA in the new century. One only has to think of the names of Christie, Walsham and Mallard. The Mallard case, especially with its echo of the Beamish confessions, has probably attracted as much attention as any case over recent times. In May 1994, an intruder brutally murdered mother of two, Pamela Lawrence, in her Mosman Park jewellery store, Flora Metallica. The Major Crime Squad and Claremont CIB quickly amassed a list of 136 suspects, including local drug addicts, thieves and psychiatric patients. Andrew Mallard was on that list. 2 weeks after the murder, he became the subject of an undercover police investigation. On the 10th of June 1994, just hours after his release from Greylands Psychiatric Hospital, police brought Mallard in for questioning. Detective David Capehorn and Mark Emmett interviewed him for 8 hours. 1 week later, Capehorn's colleague John Branham also questioned Mallard, after which, under advice from Director of Public Prosecutions John McKechnie QC, they formally charged him with willful murder. In 1995, a jury found Mallard guilty of willful murder. Trial Judge Michael Murray showed no mercy, castigating a defiant Mallard as he sentenced him to life imprisonment with a 20-year minimum. The prosecution case had succeeded by relying very heavily on the confession the police claim Mallard had made at their interviews. Mallard has largely spoken in the third person, because he claimed he was merely responding to police requests to speculate on how the perpetrator might have committed the murder. Over the next 10 years, these alleged confessions were to become the subject of intense scrutiny as Mallard continued to deny that he had anything to do with the murder of Pamela Lawrence. On September 1996, Mallard appealed to the Court of Criminal Appeal, led by Chief Justice David Malcolm. Although by this time legislation had mandated the videotaping of police interviews and confessions, the law was not retrospective. Therefore, leading prosecutor McKechnie argued Mallard's conviction was sound. The court agreed and rejected the appeal, confident that there had been no miscarriage of justice, although expressing regret the police had not availed themselves of available technology to videotape the interviews. The court did remind the police that under the new laws, it would expect them to videotape all such interviews in the future. The legislation to mandate the video recording of police interviews actually came out of the Mickelberg case. And actually it was, at the time, the police minister was Gordon Hill, one of your former colleagues. In 1997, the High Court denied Mallard special leave to appeal and frustrated Malcolm McCusker QC, who joined the growing number of people questioning the admissibility of the confessional evidence. Mallard underwent a polygraph test in 2001, the results supporting his claim of innocence. In July 2003, he passed a second polygraph test. However, the court would not consider the results of either test. Polygraph or lie detector test results are inadmissible as evidence in criminal trials. In 2002, the stubborn and sometimes testy state Labor politician and former police union lawyer John Quigley agreed to review the Mallard case. Mallard could not have done better. Quigley took apart the undercover investigation that the police ran on Mallard in 1994. He found the operation gleaned nothing the police could use against Mallard, but plenty that could have worked in his favour. Except the police and the DPP never gave this information to Mallard and his defence team. Particularly damaging was Quigley's discovery that the police failed to disclose evidence demonstrating that, according to the state chief forensic pathologist, Clive Cook, the weapon police claimed Mallard confessed to using could not have caused the injuries that killed Lawrence. The pathologist had carried out extensive tests in which he used the alleged weapon, a large wrench, to inflict wounds on the head of a pig. The experiments conclusively established that such a weapon could not have inflicted the wounds suffered by Lawrence. As a result of the new evidence, Attorney General Jim McGuinty agreed to refer the case back to the Supreme Court for a new appeal. During the hearing in 2003, McCusker for Mallard suggested that there might be a perception of bias, as former DPP, or Director of Public Prosecutions, John McKechnie, who gave advice on whether to charge Mallard and appeared for the prosecution at the first appeal, was now a Supreme Court judge. However, McKechnie's colleagues on the bench held his submission had no basis and the rehearing went ahead. Although, remember, McKechnie's not sitting on the actual appeal, but he's, of course, one of the judges in the Supreme Court. And that's why in the more recent Rainey trial, they brought in a judge from interstate because Cora Rainey was a registrar at the Supreme Court. And of course, Mr. Rainey was a high-profile barrister. The three justices to hear the Mallard appeal, Justices Kevin Parker, Christine Wheeler and Len Roberts-Smith, were unimpressed by the new evidence and after a long and drawn-out hearing refused Mallard's appeal. Len Roberts-Smith is the father of the Len Roberts-Smith that won the VC. Anyway, that's not relevant, but anyway, I thought you might want to know. They concluded there was no miscarriage of justice and that there was plenty of evidence to support the conviction. As a result, Mallard remained in jail. In October 2004, Mallard again applied for special leave to appeal to the High Court. This time he was successful, and in November 2005, the High Court overturned the WA Supreme Court's decision to deny Mallard's appeal. In a judgment critical of the state Supreme Court, the prosecuting office and the police, the High Court quashed Mallard's conviction. They ordered a retrial but suggested that the DPP might decide not to proceed on the evidence given its doubtfulness and the fact that Mallard had already spent considerable time in jail. Following the High Court's decision, the Corruption and Crime Commission announced it would hold an inquiry once the retrial question was resolved. Robert Cott QC, the Director of Public Prosecutions, decided not to retrial Mallard due to a lack of evidence. However, he reiterated that Mallard was still the prime suspect and described the High Court's decision as a tragedy, which is interesting. In May 2006, WA Police Commissioner Carl O'Callaghan announced a cold case review of the Lawrence murder and suspended a number of officers. Two of them had risen to Assistant Police Commissioner status, who were involved in the original investigations. The cold case review found a palm print left at the scene of the crime in Lawrence's shop matched that of a man already in jail in West Australia for murder. The man, Simon Rochford, a British backpacker, also matched the description of the person seen at the shop at the time of the murder. The CCC requested that the details of the review be kept secret from both the suspended officers and the public for operational reasons. In October 2006, Commissioner O'Callaghan reinstated the 5 suspended officers, saying he had seen no evidence of misconduct and announced that Mallard was no longer a suspect. Unfortunately, Rochford committed suicide in prison a week after the cold case team interviewed him and following a journalist's unsanctioned but not expressly forbidden airing of his name on a news program in Perth as the new prime suspect. Thus, officially, Pamela Lawrence's murderer remains untried. Both O'Callaghan and Robert Cott QC publicly apologised to Mallard for the 12 years he spent in prison. And in November 2006, Mallard received an interim compensation payment of $200,000, with the state government raising the possibility of more to follow after the CCC inquiry, which he did actually receive a greater payment later on. The CCC report was released on the 7th of October 2008. The report cleared some police officers, the chief forensic pathologist and Cott QC, but it opinioned a combined 6 charges of misconduct against Assistant Commissioner Mal Cheville and David Coburn, including withholding information from the defence and causing witnesses to change their statements. The inquiry made 2 opinions of misconduct against prosecutor Ken Bates, including the non-disclosure of significant forensic test results to the defence. In discussing these cases, I do not want to make light of the difficult job that police, lawyers and judges have in ensuring that the right verdict is forthcoming. But what we must do is always ensure that justice is done and seen to be done. That may be difficult, but it should not be difficult to behave in a proper and moral way. And when it comes to police corruption, it is never accepted, even so-called noble cause corruption, where the police are certain someone is guilty, but they act in a corrupt manner to fabricate evidence to ensure conviction of someone they are certain is guilty. That can never be acceptable. If corrupt police get away with it, an innocent person might go to jail. Second, if the court uncovers behaviour that corrupts the judicial process to the extent that a jury does not have before it all the evidence, or has before it evidence that the police officers are corrupted in their zeal to get the job done, a guilty person might go free. In each instance, the public have been let down and the integrity of the police force has been tarnished. And in relation to the judicial process, the court process, the rules of evidence may exclude evidence that may result in someone not being found criminally guilty, even though they actually did the crime. But I remind you of the famous dictum of English jurist William Blackstone, who back in the 1760s said, "It is better that 10 guilty persons escape than 1 innocent suffer." Well, that is what is normally cited, but the full quote is as follows: "All presumptive evidence of felony should be omitted cautiously, for the law holds it better that 10 guilty persons escape than one innocent person suffer." Thank you. And as is the usual, open to questions.